everyone, and thank you so much, Rachel, for the introduction. I'm really excited to make this presentation today. Let's jump into it right away. Today, I'll be talking about, as Rachel said, acquiring intellectual property. If you think about intellectual property, it could be very amorphous. It's a basic idea, innovation, invention that you are trying to somehow market, sell, license, and make profit out of it. So there are two important parts of it. One will be making this, establishing your invention or innovation to become a right so that it could be actually tradable and can be used in commerce. And that's what I'll be talking about today heavily. So moving on to the next slide. There are intellectual property could be a lot of things, but there are definitely four big categories when it comes to intellectual property. One is a patent. It could be a process, machine, article manufacturer. It could be a lot of things. So patent is one category, and I'll definitely talk a little bit more about it as we go on. There is a trade secret, and what trade secret is confidential information which is valuable as long as it's kept as secret. A big example of trade secret is Coca-Cola. They have decided to keep the formula to make Coca-Cola confidential so it could be used and it's valuable because it's a secret. No one can copy it. The other thing that is well known is trademark. It could be names, logos, trade dress, the slogan for goods and service. Think about logos and names like Chanel, that CC logo on your purse. Or if you think about slogan, Make America Great Again by Trump administration is a slogan. So when we talk about trademarks, it's typically when you can immediately connect that trademark with the originator, then it could be a trademark in a lot of sense. Copyrights is an expression of idea in a tangible medium. You can think about a lot of art form as a copyright when you put it in a tangible medium like paper, film, CD, MP3 format. So copyrights, a lot of things includes music, movies, things like that, a book that can be turned into a tangible medium. Today, I'll be talking heavily about patent, but these four things can be all intellectual property and a big categories of intellectual property. And as you see how your intellectual property fit into these categories, you can decide what kind of strategy is proper for your company. So what is patent? Patent is a right to exclude others from making, selling, using, or importing claimed invention. And I'm going to talk about a little bit of government policy behind that because it helps a lot for people to understand why the government is giving patent and why certain law exists. Government wants to foster people to have innovation. We want people to invent. We want people to make invention. And that is only possible. It is only possible for us to really progress if we will be able to exchange information in a free format. So government, but that kind of goes against our intuition as to, hey, I spend a lot of money, a lot of resources in creating this invention, so why would I want to disclose it? So in exchange for a right to exclude others for 20 years, you are disclosing the details of your new technology so that the government can give you this right. So, and keep in mind, however, it does not give inventor or owner a right to practice the patented invention. So it does not, just because you have a right to exclude other doesn't necessarily mean I have a right to use it. So why patent invention? It could be a lot of reasons. Number one is it's a good source of recognition of an inventor. You made an invention. You want to put it in a much more established format or in a more concrete right. And patent can be exact that. So you are putting your invention in a format that is a little more recognizable. So that's not one of the one big incentive. The other incentive is it could be a gateway for you to develop a commercial products. When you have it in a very clear format where people can understand what your innovation is or what your inventions is or your ideas, it could actually, you can actually connect, partner up with another people and then make them develop a commercial product based on your technology. Again, and another good thing is protection against competitor. You can monopolize the market a little bit more by having a patent. So what can be patented? So exact legal terms as to what can be patented is anything under the sun, except for abstract idea or law of nature. And this is a very broad form. So it could be anything. It could be a composition of a matter, formulation, mixtures, polymers. It could be a machine. It could be a machine like iPhone. It could be an article of manufacture, films, foams, fiber, process or a method, wafer manufacturing process, encryption, extraction. All these things can be patented. So if that's the category of what can be patented, let's explain a little more in detail as to what is required for an invention to be patented. Number one, it has to be novel. It cannot be, it's not something previously known or used by other, but it has to be novel. It has to be useful. It has to have a known use or produce a concrete and tangible result. Think about time machine. We all know that, time machine, the idea is fun, it's very useful, but it does not give a tangible result. We all know time machine doesn't really happen. Next one is a non-obvious. When we talk about non-obvious, it's a little bit different from novel in a sense. It cannot be a simple combination of patents or known art that will yield a predictable result. So when it's very commonly thinkable for people to combine one or two more ideas or combine it together and come up with a new idea, that's when we call it a non-obvious. So what can be patented? What do you mean by ideas, law of nature, scientific principle? So when we talk about this, we are talking about really a law of nature. So let's talk about calculus. Calculus can be used in so many different formats. However, the calculus itself cannot be patented because it's a law of nature. It is something that exists and that is already a scientific principle that is proven. All right, so what are some considerations when it comes to filing a patent? The common thing people think about is how much is it going to cost? How long will it take? Do I need an international protection? Do I want to file provisional or non-provisional? Should I hire a patent attorney or a patent agent? And these are all excellent questions, and this should be coming up to your mind as a business person. It's all balance of cost and the benefit of it. So these are some of the questions you may want to ask your attorney or your patent agent before you file your patent application. There are different ways we can customize it, so it could be it could suit into your situation, and you can get a maximum benefit out of this whole patent filing process. What kind of patents are available? There are three types of patent that are available. Utility patent. So for new and useful process, machine, article, manufacturer, composition of matters, any new useful improvement. So I have this little drawings right here as an example. So for example, Apple iPhone itself is a utility patent. It has different features in it. You can make a phone call, you can use an app on it, it has different features. So that will be a utility patent. Design patent is for ornamental design of a product. Commonly used way is perfume bottles. When you see this design pattern right here of iPhone, so how it's rounded on the corner, how it has like square shape as a display. The look of it is more of a design patent. Plant patent is when you see a mixture of plants to make it a patent. Let's say I mix strawberry and cherry and make cherry flavored strawberry. That will be more of a plant patent. All right. So I don't know if how many people here have seen a patent, but as I said, going back to the original idea of government policy behind it, the government policy behind it is, hey, you make a disclosure of your invention and I'll give you 20 years of monopoly of this particular invention. So what government want in exchange of giving you a patent is your clear explanation of what your inventions are. So typically, patent will have 5 parts. There's abstract, where it's going to be a summary of invention. And so you're going to describe in simple format what your inventions are. You're going to describe, there's going to have a background of invention where you basically describe why you came up with your invention, what's the benefit of your invention, and then you have a drawing, an image of invention. If it's a process, it will be a steps as to what your inventions are. Specification, this will be a detailed description of your invention, how it works, what they are, how which part acts with what. Claims, and this is one of the most important part, is going to be describing exactly what your rights are. What you can exclude people from using, making, selling is going to be your description under the claim. All right. So who may file for patent? Inventor, a person to whom the inventor has assigned or is under obligation to assign the invention may apply for patent. So it could be an inventor, it could be an employer, it could be someone who bought your idea, could file for patent. A legal representative, let's say your minor child, your 17-year-old came with a great idea, then your legal representative, the parent, can be a person who filing for patent. We can have a joint inventor. Invention can be multiple people doing it together, and 2 or more people who make an invention jointly can be a joint inventors. Just keep in mind, a person who makes only financial contribution is not a joint inventor and cannot be joined in the application as an inventor. You can own a patent, but that doesn't necessarily mean you are going to be a joint inventor if only contribution you make is financial. If there's anything you need to take away from this webinar today, it's going to be this last slide from me. Bar dates for filing patent. This is the most important part of my webinar today, so please, please, please focus. But government doesn't want you to, it gives you a timeline for it, which is 12 months. So upon disclosure, you have 12 months to file your patent application. And if you do not do that, the government is going to think that you made a very generous contribution to this world. By disclosing it to the public and not filing patent application within 1 year from that date, you are not going to have a right to file patent application anymore. This is a bar, it's absolute bar. After 1 year, you have no right to file a patent application anymore. So keep that in mind, it's really important. I have tons of great ideas that come to me that a lot of people do not know about, but at the same time, they made some publication, some disclosure at some kind of meeting 2 years ago, and we're out of luck. We cannot file a patent application on that invention anymore. So when we talk about public disclosure, what is that? It's either described in a printed publication anywhere. It could be a small article. It could be your letter to another company explaining your invention. It could be one of those. So any description in a printed publication anywhere. And secondly, publicly used in U.S. If you gave it a sample to your friends and your friends start really enjoying it and using it all over, that's going to be a disclosure. If you offer for sale in the U.S., let's say you took it to a trade show, even though there are only 5 people available, if you offer it for sale, that's going to be considered disclosure, and the time starts clocking. So you have to remember, 1 year from disclosure date, you have to file patent application in between. And of course, not all disclosure necessarily mean immediate bar, but there are other ways we can protect it. Kumar will be explaining a little bit more about non-disclosure agreement, confidentiality agreement, where we can make it a non-public disclosure. But however, as soon as you do your public disclosure, you have to file your patent application within 1 year. Foreign patent must be filed. If you file a patent in another country, your application has to be filed within 1 year from that foreign application filing date. So please keep that in mind. That's all for me today. And if you have any question, please do not hesitate to contact us.
You can go ahead and get started on that, and we'll go ahead and start. We've got a question here from Raj asking, can one patent software algorithms? What do you think, Sul? I think
not the algorithm. Algorithm is basically mathematic formulas. As I said earlier, it's not really patentable. There's a way to patent software, though. I'm not trying to say all softwares are not patentable. There was a Supreme Court case that came out several years ago that pretty much create a kind of dead end for software, but that is still, there's some way to do it. You have to connect it with a machine, like computer. Have to have different feature involved in order for a software patent to really happen, but truly trying to patent a software algorithm is not going to work.
What exactly is the benefit of a provisional patent application? Shouldn't I first have a proof of concept and commercial product before I bother filing any patent application?
As I said, the proof of idea doesn't have to be there. You don't have to actually have a sample, and that's what a lot of inventor comes in and then tell me, hey, I'm working on my sample, so I'll wait until that thing is done for me to file a patent application. No, as long as your idea is enabling, if it's working, we can file a patent application right away using your idea and putting in the description about it. So you don't need any actual sample. So provisional application is like a placeholder. Let's say you came up with the idea and you somehow disclose it, and today is 2 days before I actually lose my 1 year date. Then you have to put something on the USPTO, otherwise in 2 days you're about to make a nice contribution to the world. So provisional patent application is commonly used for that purposes. Sometimes it's used for a lot of startups when they don't have the fund to do a full-on non-provisional. Provisional application preserves the priority date, basically, assuming that no public disclosure has been made yet. It's not going to be published. It's not going to be examined. But you have 1 year from the provisional patent application date to file a non-provisional application and start it going. So that's the whole purpose of provisional. A lot of people put in provisional and then start commercializing things to kind of see how the market reacts, and then actually commit to non-provisional. And a lot of provisional actually go. A lot of provisional get abandoned as well, because people put it in the market and then realize that it's not really marketable.
Okay, here's another question. Should I also file international patents? And what does that entail?
Yes. International patent is, let me share a screen on it, is really, there's no such a thing as really straight up international patent. There's no patent that covers all internationally. Whether you are filing an international patent or not is really should be part of your business plan. And good thing about it is there's something called PCT. So it's file a patent cooperation treaty, PCT application, then later designate your country. So if you look at the timeline, after you file your patent, you have 12 months to file a PCT, which will allow you for 18 months to decide which country you want to file your patent application. And it really depends. And as I say here, if you look at the timeline, it says file local application, and then you file PCT application. You have 18 months to go into a different national basis. And because of this flexibility, the reason a lot of people recommend to do PCT is you never know which country is going to pick up your technology. That's one thing. And the other thing is, if you think of a long-term plan, think about it. Okay, where am I going to manufacture? Where am I going to sell? Where am I going to, license and all that? And when it comes to patent, right, U.S. patent is not applicable in China. Every country has their own patent law. And because of that, just because you have one one right in one country does not mean you're going to have a right in another country. And as I said, disclosure, if it has been more than 1 year from the date you disclose, then you lose your right too. So because of that reason, PCT is a nice, nice tool that you can use to hold another 18 months to decide which country you're going to do. I mean, obviously, doing it all 135 countries is not easy. You do have to choose which country is going to be most valuable. Commonly, I see, just a short recommendation, commonly I see a lot of people do EU. EU has one nice, patent now. And the other country that is commonly I see is China now. Although their protection is not as strong as the other country, is our common belief. But at the same time, the patent is 20 years. You never know what's going to happen in 20 years. India, all those countries, even with the country that has relatively, weaker intellectual property protection, 20 years is a long time. You'll really never know.
Well, earlier you mentioned about Coca-Cola keeping their formula as a trade secret, and they didn't patent it. When would you choose not to pursue a patent and just try to keep something a trade secret? How would you make that choice?
Yeah, and that's the benefit of a trade secret is that there's no timeline. Patent application has a timeline. You have 20 years, but after that is a public knowledge. And also, you have to think about there's different strategy in deciding which way you're going to go. And this is something I strongly recommend a lot of people to talk to an attorney who knows what they're talking about. Because you do have to make a distinction as to, hey, is it really possible for me to even keep that trade secret? As you said, Kumar was talking about, hey, you have all these friends who wants to give you money, right? Or who wants to do things together with you. Can they really keep that secret together? Because trade secret is only valuable when you can keep it a confidential information. But once it's out, yes, we can fight everything at the court, but it's out. So that's really a business judgment call, I would say. If you can keep it a secret, and if, the other thing that I would think about is derivative invention as well. You have a base idea and a derivative of it. Can that be valuable or not? I think those can be all standard in deciding which way to go.
Okay, well, we're almost at the top of the hour, so I'm going to ask one last question. And that is, what are some of the common mistakes that you see? What should people be looking out to avoid?
I know no one wants to spend attorney fees. I, as an attorney, don't want to spend attorney fees. So I totally get it. But just like there's sales, marketing, technology, and different part of your business, legal should be part of your business as well. And if you do not, it's important for you on a day-to-day business. It's so busy. A lot of business owners have so much thing going on. And I understand that legal is the last thing that you want to think about. But it is a part that you do have to keep an eye on. Look over your process, like where things are leaking. Your employees, tons of you, I'm pretty sure, do not have employee handbook, good non-compete agreement, non-solicitation agreement, technology assignment. If you start just paying attention once a month and then just have a regular meeting with occasionally going over your legal issue, that alone will save you so much money later when it comes to an issue. When you just put it on a back burner, don't think it as part of your business. If you think it as, okay, it's an evil that happens to only bad people, that mindset will really catch you. And trust me, no one in the litigation is that evil. It's really people working so busy, doing things all over, and then later they're caught with the problem and then they have to solve it now. Much more expensive way, in a much difficult way. And you don't want that. So just keep that in mind. It's part of your business. You do have to pay attention. Try to spend a little bit of time, at least once a month, is really my recommendation, to kind of go through your process. What are the things that I need to make sure that I have a paperwork and all that?